Landlords and tenants. Money. Renting out of residential premises is a business, and so there's always going to be money and money issues involved. So we'll talk about a couple of them. One big issue is bankruptcy. When the tenant declares bankruptcy, it does not terminate the lease. Even if there's an immediate termination clause in the lease, the law says that the lease itself does not terminate. What it does is it triggers something called an automatic stay. The automatic stay goes into effect, and so the landlord cannot deliver a termination notice or proceed with an eviction for the lease violations during this time. An automatic stay is kind of like a freeze. Everything has to stop while the bankruptcy is going through the court system. Now, the stay can be lifted. That means the landlord can actually go to the judge and ask for relief from the automatic stay, or for the stay to be lifted, so the landlord can actually go and enforce a money judgment or can go and finish with an eviction lawsuit. This happens mostly in non-pay cases, though the tenant can still sometimes stop the eviction, and judgments for possession can be enforced even if they are obtained before bankruptcy. So it will not stay, say, a writ of execution, for example. So tenants who believe that filing a bankruptcy is going to keep them from being evicted, that's usually not a good idea. Even if they get an automatic stay, which is going to freeze procedures for a little while, the landlord can often get relief from this and move forward without regards to waiting for the end of the bankruptcy. When the bankruptcy is that of the tenants, the landlord may not use the security deposit to offset past due rent. This is a violation. They may be liable for the tenant to act for actual damages or punitive damages. Of course, you have your 4 types of damages, so your actual compensatory nominal damages, for example. And so, and that D should actually be a P for punitive damages. The tenant / the bankruptcy trustee is going to decide what to do about the lease. They can either choose to assume it, which means to keep it and keep going on with it, or to reject the lease, which means the opposite, means to stop the lease. If you file a Chapter 7 bankruptcy, then you have 60 days, and if you file Chapter 11, 12, or 13, then it has to be done before reorganization plan is actually confirmed. So the tenant is going to have to make that choice. If the bankruptcy is that of the landlord, they have the same choice: assume the lease or reject the lease. If they decide to reject the lease, they empower the tenant to do a couple of things. First off, the tenant would be able to treat the lease as terminated. They can move and they can sue for damages. And they can also stay until their lease expires and apply to the bankruptcy court for an offset against the rent if the landlord can't make repairs or deliver other services. Important to remember that bankruptcies are happening in bankruptcy court, which is federal court. Evictions and the like are going to be state court matters. So sometimes you can have both going on at the same time. And so it's important to know which form you're in. Other deposits, fees, and last month's rent, so important things to talk about for all tenants and landlords, regardless of whether they're going through a bankruptcy issue or not, is that these things are refundable. Deposits and fees to cover unpaid rent, cleaning, or damage beyond normal wear and tear. That's the deposit. And so they can charge, a landlord can charge for credit checks and screening fees up to $33, which would not be refundable. However, there are limits on the deposits that can be asked for. In an unfurnished apartment, the total may not exceed 2 months' rent. In a furnished apartment or home, the total may not exceed 3 months' rent. For a pet, you cannot charge, like, say, pet deposit fees for a service animal, as long as that service animal is for a legally recognized disability. The deposit may not be increased unless the lease allows for it specifically, but if the lease is a month-to-month lease, so it's not a lease for 6 months or a year for a certain term, then the landlord can increase the rent or make other changes to the lease itself after 30 days written notice. Sometimes there are jurisdictions that have rent control which will prohibit this, but generally you're just looking at that 30 days notice and they can change it. If the rent is increased and the deposit is a multiple of the rent, the deposit may increase as well, although it may not be excessive. The landlord must give the tenant the opportunity to be present at an initial move-out inspection. It's always good for the tenant to make sure that they request this before they move out so that the landlord can identify probable security deposit deductions. This is where the landlord gets to walk through and say what the problems are and give the tenant a chance to cure them, or to give the tenant a heads up as to what different things are going to have to be repaired, which will take money out of the security deposit. The landlord must schedule it no sooner than 2 weeks before the planned departure, and they have to give at least 48 hours written notice of the day and time. They can't just come in. The written notice that has to be there must be sent before the tenant's planned departure. So we're really looking at making sure that this happens before the tenant moves out so the tenant can be there and watch what's going on. The landlord can deduct for problems which are not fixed. So if the landlord goes through, identifies things, and then doesn't actually do anything, and then the tenant actually doesn't do anything about it, the landlord can deduct for those problems, or if there are problems that appear after the inspection. So say the landlord walks through and does the inspection, then after the landlord leaves, 2 days later, the tenant actually, just goes about and trashes the place. Then the landlord, when the landlord comes back and recognizes that this has happened, the landlord also has the right to deduct for that amount. Interest and return of deposits. The landlord doesn't have to pay interest under state law, but some local laws require it, particularly in rent control jurisdictions, but here's the list here for you to know. So, Berkeley, East Palo Alto, Hayward, you may be in one of these areas, and so you want to check in to make sure that you don't have interest, which may be due back to you. But no matter where you live, the landlord has 21 days in California after the tenant vacates to return the deposit. So a couple of things have to happen. Either the landlord sends back a written itemized list with the deductions of how much you're taking from the security deposit, and so therefore your $1,500 security deposit is now eaten up by these fees, which have been all carefully enumerated for you. Or the landlord can send something with deductions that says, this is how much I had to pay to replace this which is broken, or replace that which is broken, and so we'll be taking out $600 of your deposit, and here's a check for the remaining $1,100. Or they can just give the check back, but they have to make sure that they do this within the 21 days. They can only withhold amounts necessary to pay overdue rent, repair any damage, clean, and replace personal property. That's about it. If they don't do that, then they can be liable for not only the entire security deposit being returned, if they don't give that itemized list within 21 days, but even possibly more times the amount